Hi everyone, welcome to today's webinar, Adults and Children in the Criminal Mental Health Immigration Systems, Present Challenges and Advocacy Efforts. My name is Emily Scahill. I'm the Manager of Public Education and Awareness at Mental Health America's National Office, and I'll be moderating today's webinar. Some notes before I hand it over to our presenters. This is a 90-minute webinar rather than our typical 60-minute webinar. So we'll have an hour of presentation and then a 30-minute Q&A session. We are recording this webinar and I'll send the recording out to all registrants within the next week or so. You'll also be able to find it archived on MHA's website at mhanational.org/MHA-webinars. For the Q&A, please post your questions in the chat box throughout the presentation and we'll go through some at the end. And feel free to make comments or share some of your knowledge in there as well. And lastly, we do not offer CEUs, but if you would like a certificate of attendance, we have a form for you to request one. I'll post the link to that form in the chat and it will also be included in the follow-up email. And now I'm so excited to hand it over to today's speakers from the Vera Institute of Justice, Gregory Pleasance and Derek Lowe. We're so excited to have them with us today, and I will turn it over to Gregory to get us started.
Thanks, Emily, and hey, everyone. Thanks so much for being with us today. I'm Gregory, and this is my colleague, Derek, and we'll formally introduce ourselves in a second. But hey, this is Adults and Children in the Criminal Mental Health Immigration Systems. We're gonna talk about some of our advocacy efforts and some challenges and build relationship with you all. So we are really excited to be here. I'll just say right up front that I love MHA. I love how you stand for recovery. I love how you are inclusive. I love the prevention work that you do. I'm a big fan, and so it's an honor to be here. And I want to name that. So we'll introduce ourselves. Derek, why don't you introduce yourself first, and then I'll go.
Yeah, great. Hi, everyone. Good morning, good afternoon. My name is Derek Lowe. I work at the Vera Institute of Justice in our Immigration Center, and specifically on a program that works with unaccompanied immigrant children who are in the United States. Before coming to Vera about 1.5 years ago, I did direct immigration legal services for about 5.5 years at a nonprofit in LA called Immigrant Defenders Law Center. And that's who I am. I'm based in California, and I live in Los Angeles. Gregory?
Sure, thanks, Derek. So I'm Gregory. I'm also an attorney. I'm also a social worker. Love social workers. Hope there's some social workers in the crowd today. I have a background, I started my career defending people with mental health conditions who were in immigration custody. And I've been a public defender at the state and federal level. And I've also worked as a clinician in a mental health hospital. And I am an adjunct professor of law and social work. And at Vera, I work to build out legal defense systems for immigrants with Derek. And so that's us in a nutshell, and happy to be here. I am going to, let me turn now and give a brief presentation overview. I'll walk us through what we're going to talk about today and give you some sense of what our timing will be in the presentation, and we'll go from there. So the upshot is I'm going to walk us through about roughly the first half of our presentation to cover much of what you see here. And then I'm going to hand it off to Derek for another half hour, and he'll do kind of a deeper dive in the question of minors, children impacted by these immigration and mental health systems we'll be discussing today. So about half and half, and then we'll do 30 minutes for Q&A or comments at the end. So just top level, we've introduced ourselves. We're in the presentation overview. We'll talk about some goals in a minute, what we want to accomplish here with you in the space. I'll spend a few minutes talking about where we're coming from as people who work at the Vera Institute of Justice and Vera's Center on Immigration and Justice. That's where Derek and I work, and we want to tell you a little bit about some of our strategic areas and how they may connect to your work. I'll spend some time talking about the pipelines that we believe connect the criminal, mental health, and immigration systems. That's one of our key takeaways today. We want to discuss this pipeline with you. And then I'll give some background on the immigration system that I think is relevant to you and your advocacy and work. Then I'll finish my section talking very briefly about the NQRP. Sorry for the acronym. It's a program that provides legal help to people with mental health conditions in immigration detention, and it's been a success story, and I want to share it with you. And then Derek will talk about some of his work with kids in these systems. And then we'll do some Q&A. Let me talk a bit about our goals. And the first, I think, and most important goal here is that we want to lift y'all up. We want to lift up the work of the mental health advocacy community, because as you'll see today, some of the challenges that we're facing and in our work, in our immigrants' rights work, and some of the victories that we've had is built on top of successes that you have had. And so we are, in a sense, standing on your shoulders. You know, we're trying to bring a person-centered frame to working with people with mental health conditions in this legal setting. We are trying to say, to challenge certain practices that are harmful to people with mental health conditions in the detention space. And we're building on your work. And so I want you to know that, and we want to honor that. We want to share some of our knowledge and values and ideas, and hopefully some of that resonates with you. We want to overlap or identify points of overlap in our mutual advocacy. And to go to that bottom point, I hope to create some solidarity in our work so that we are all working towards increased protections and rights for all people with mental health conditions, US citizen, non-citizen alike, adult, child, all people, and all people with mental health conditions. And then I think too, Derek and I want to sound the alarm bell a little bit and say that some of the practices that you as advocates for people with mental health conditions have faced down in the past, the abusive and illegal use of segregation in detention spaces, the overuse of restraints, overt discrimination against people because of their mental health conditions. You've had great successes in fighting some of those challenges, but they're coming back in this new immigration enforcement space. And we want you to know that, and we want to do some of this work together with you. I want to say very briefly where sort of our values and where we're coming from. Just very unequivocally, we are coming from a point where we believe in a country that guarantees justice, fairness, and freedom for immigrants, recognizing the full humanity and dignity of all immigrants and all people, full stop. And we fight to achieve that vision. And it's important to name those things here up front. Derek will speak to the other two important points.
Yeah, we wanted to make the note as well that when we refer to the communities that we work with and that we'll be speaking about today, we use the words people and immigrant, people with mental health conditions, things like that. And we don't use the word alien, which is something that you'll see in official government documents in the media. You know, we believe those words are racist, pejorative, and they dehumanize some of the most vulnerable people that are in our communities. And also just want to make clear that we believe that immigrants are people who deserve full human and legal rights, and our systems should treat them as such. We should not treat them differently just because of their countries of origin. So back to you, Gregory.
Yeah, thank you, Derek. And I'll say too, just that highlighted piece at the bottom, one of the reasons that I think you should care about today's presentation, I know that you do, but it's worth saying that we believe that as systems treat one group of people with mental health conditions, so they treat all people with mental health conditions. So we should be on guard against giving a pass to systems, and we see this unfortunately in our immigration systems today, that tolerate or engage in prejudicial or oppressive or discriminatory conduct against people with mental health conditions. We can't be okay with systems like that anywhere. So I call to the group that we want to change the systems that we work in, the immigration system, so that all people with mental health conditions are treated as in a person first, dignity first way. And we as a community want that for all systems. And so that's where we're coming from. So let me just skip to this slide. Here is, Derek and I work in a place within Vera called the Center on Immigration and Justice. And I want you to know a little bit about our 4 areas of strategic work, because I think that you'll find resonance with them. One thing that we're trying to do, one of our goals is to ensure that all immigrants impacted by the immigration system have legal defense. And that the structural conditions in terms of funding, in terms of holding legal defense to a standard of professionalism and zealousness exist as well. And that is key because unlike the criminal system, there is no general right to legal defense in the immigration system, even though the stakes, life, liberty, property, are the same that you would find in the criminal system. And it won't surprise you to hear that when an immigrant with a mental health condition is standing alone before a judge with a trained government prosecutor on the other side and is also detained, that that person has very little chance of being heard without legal representation and defense. And so we want all people in the immigration system, and particularly people with mental health conditions, to have legal defense. We are also focused on reducing the harms of immigration detention. You'll see later in this presentation that immigration detention is just another carceral setting, and a huge one at that. Don't let the name fool you. It's jail and prison by another name, and the same pernicious harms that exist in jails and prisons, particularly for people with mental health conditions: segregation, no mental health care, the abusive use of restraints, exist in the immigration detention setting. And it's just another setting where people with mental health conditions are deprived of freedom and autonomy. And so we are laser focused on reducing the footprint of immigration detention and eventually getting to a place where we don't have immigration detention. And then third, we are very mindful of the way that the criminal, mental health, and immigration systems are connected. Depending on who you are, if you touch one of those systems, you are literally sucked into the rest. And we'll illustrate that later on in perhaps more academic terms. But the important point to make here is that these systems contain inequities, each one of them standing alone. And as one travels along these systems, those inequities compound, particularly where race intersects and particularly where mental health status intersects. And so we want to give folks a ramp off of that pipeline. And then finally, we want immigration judges, to be more accountable. It wasn't just 2 years ago where the American Immigration Council and the American Immigration Law Association released a report about an immigration court in El Paso that alleged that immigration judges there characterized their court as the bye-bye place and mocked people with mental health conditions as crazy and as undeserving. And that behavior is endemic in the immigration system. And anyone serving in a judicial capacity should not show that kind of prejudice towards people with mental health conditions. And we want to increase judicial accountability in the system. So those are our 4 major priority areas. Let me say a little bit about the immigration system. I won't read this slide. I won't get too in the weeds. But look, we're talking about a federal system that is populated by folks from cabinet level agencies. You have the Department of Justice involved, and the Department of Justice runs the immigration court system, where lots of immigration cases are decided. Immigration judges are appointed by the Attorney General and subject to that person's influence They are not independent Article 3 judges. And then the Department of Homeland Security, another cabinet level agency, is in charge of immigration police. ICE, Immigration and Customs Enforcement, is a subpart of DHS. So those are some of the actors you'll see in the system. Immigration court is just like criminal court. There's a judge, there's a prosecutor, and there's someone there who's being accused, in this case, of being deportable. And for that person, everything is on the line. The right to remain here with family, the right to be free of violence and discrimination in the country of deportation, if that happens, except there's no right to legal defense in this setting. And we, as I said, are pushing back hard and trying to change that. And then there's this immigration detention setting, which, as I said, is just another carceral setting that is identical to jail and prison. It's characterized as civil detention, but that legal distinction in practice means very little. And the same harms you see in the jail and prison setting are the same harms you see in the immigration detention setting. And let me just also give you a sense of the scale of the immigration system. You know, if you don't spend time in these systems, if you're not directly impacted or professionally working in these systems, there's perhaps not, you might not know this, but this system is huge. Its reach is vast. You see here that whether it's people becoming permanent residents or US citizens per year, or the number of arrests and apprehensions, people who move through the system from that end, it's millions of people per year. And in terms of immigration detention, you know, this is a $3.5 billion system that detained 500,000 people in FY19. And it's a hodgepodge of directly government-run detention centers and contracts with local jails and mental health hospitals, for that matter, and private detention contractors. And so this system is huge. And so there's a good bet that wherever you are, and I know folks are joining us from all over the country, wherever you are, this system is manifest. And so you should know that, because if you're in the business of advocating for and working for and alongside of people with mental health conditions who have any involvement in the criminal system, or for that matter in the public mental health system, they may well touch this system too. And you should be aware of its scale and impact. And I'll say too, though, even though we know a lot about its scale, there's a lot we don't know about it. For example, we don't know how many people in immigration detention have mental health conditions. We have some educated guesses that we can make based on what we know from the criminal system, but that opacity, that lack of transparency is part of the problem, because when people are invisible, then that's where impunity and harm occurs. And so we do want to flag that even knowing who is in these systems is a challenge. Let me say a little bit about the immigration court, what it looks like. And I ran this slide by my wife and I asked her, is this comprehensible? And she said, yeah, you know, she was being very kind. She was like, there are a lot of shapes. But look, so you imagine, so there's the person there at the bottom of the screen where it says person. And that's the person who's in immigration court. And arrayed against that person is an immigration judge there to the top left, a prosecutor, a government trained attorney there on the top right, and the specter of being locked up during this process, immigration detention. And as I said, at stake is everything that makes life worth living. And that's a direct quote from the Supreme Court. And mindful, this is a legal process that courts have called second only to the IRS code in complexity. So if you are an adult who's detained and without legal representation and struggling with a mental health condition, or if you're a child in front of this system with no help, you don't have a chance to be meaningfully heard. And I want that to be very clear. And that's why I wrote no power and power, in the descriptors on the left, because this is what this system, this immigration court snapshot looks like day in and day out. Let me say a bit about these system connections. And this, again, is one of our key takeaways. I am told that this crowd, and I'm confident this is the case, understands that the criminal and the mental health system are connected along a number of points. And, I've named a couple of those points over to the left, everything from, trans-institutionalization in the wake of deinstitutionalization that pushed some folks from the state hospital system to jails and prisons, from the work that some of you may well do in a forensic capacity in terms of competence to stand trial, or restoration of competence to stand criminal trial. That's a point of connection between these systems. Of course, all of you are familiar with the mental health court systems and other problem-solving courts in the criminal system that touch mental health, and some other points of connections. And you're also familiar with how important it can be to break that connection, diverting people with mental health conditions away from the criminal system and towards treatment, eliminating onerous cash bail that traps people, particularly people without resources who may have mental health conditions in the jail system when that needn't be the case. I want to add a third system to that connection, and that's the immigration system. And let me explain that connection a little bit. One thing that I think should be stated is that we are in a world of integrated law enforcement databases, where there's just a great deal of information exchange, particularly among the criminal and immigration systems, but also increasingly among the mental health system. And there are local efforts, local efforts, like SB 54 in California, to limit that information sharing, but these systems are connected just in terms of information sharing in a way that is increasingly the case day after day. I want to name two that one thing that is so difficult and harsh, draconian even, about the immigration system is the legal effect it gives to even minor criminal convictions. So any touch with the criminal system, a trespassing conviction, a loitering conviction, a DUI conviction, any conviction related to drug possession, has outsized or can have outsized a legal effect in the immigration system, including stripping one of immigration status, making one ineligible to be released on bond if in immigration detention, and other kinds of effects. And the immigration and criminal system are linked by these detainers. So immigration agents will say, hey, we see that someone in your criminal system has suffered this or that conviction. We think that makes the person deportable. We're going to place a detainer on that person so that even if that person makes bond in the criminal setting, they've got to come over and be detained in this system. And a lot of people get moved from one system to the other in that sense. We also see ICE immigration police in mental health spaces. We see ICE contracting with private psychiatric hospitals to provide what they call acute care, not to get people better, but to make them stable for deportation. That's how ICE regards its legal treatment obligations. And I'm aware of anecdotal situations where ICE has said, because we're putting this person in your hospital, whatever your state law says about patients' rights don't apply to this person. We are aware of examples like that in California, and I think probably those kinds of, and I think legally wronged arguments ICE has made in many different states, but they are in private mental health hospitals, and even in state mental health hospitals to screen people for deportation. Even in some cases, a not guilty by reason of insanity criminal disposition can be grounds and regarded as a conviction in the immigration system. So increasingly presence in those mental health systems. And, I just want to say, again, and Alina Das, in her article, Inclusive Immigrant Justice, which I really want to lift up, and if you want to know more about the connection among these systems and the compounding inequity that race plays among these systems, you should read her article. But to the extent that being Black or brown or being a person with a mental health condition makes one more likely to have encounters with the police, and I think it does. That also increases, that's a point of entry into the mental health system, that's a point of entry into the criminal system, and that can turn into a point of entry into the immigration system. So the key takeaway here is that these systems are connected, and that if you are working with people and you have a person you're working with who is an immigrant, then the possibility of being drawn into this very punitive system is real, and you need to be aware of that as an advocate. Let me end my remarks just by talking about a victory, a relatively recent victory that I think I love, and I want you to love too, because part of the victory is yours. So I said earlier that there is no right to legal defense, no right to counsel for people in immigration proceedings. And that is true with one notable exception. There is a very recent right to counsel for people who are unrepresented, who are in immigration detention, and who are found mentally incompetent to represent themselves in immigration proceedings because of a serious mental health condition. And I'm sorry for that legal language, but that's actually the legal criteria. The National Qualified Representative Program, the NQRP, is the program that was created to provide defense counsel to people who meet those criteria. And the background of what created the NQRP is a story of how mental health law can be leveraged for justice for immigrants with mental health conditions. And let me say what I mean. The case I'm talking about is Franco Gonzalez v. Holder, a 2010 case that made the following claim. It said, in essence, it is a violation of the Rehabilitation Act of 1973 to subject a detained immigrant who has a serious mental health condition to immigration proceedings without the accommodation of counsel. A straightforward accommodations argument. That suit was successful and created the right to counsel in part of the country. It wasn't a national scope. It created the right to counsel in California, Washington, and Arizona for the class of people that represented immigrants with mental health conditions in detention. But it was so cool because the immigrants' rights field had for years tried to argue that the due process clause, just due process, requires counsel for these folks. Because if you're in detention, struggling with mental health, and by yourself before the court, you don't have a shot at being heard. Those efforts had not been successful. But this accommodations argument was. And the argument turned on the stories of Mr. Franco and Mr. Gomez Sanchez, two named plaintiffs, and their information is public, which is why I'm sharing it here. They were men, Mr. Franco with a very serious intellectual disability, and Mr. Gomez Sanchez with schizophrenia that was severe in its impairment. Two men who were drawn in who were both permanent residents, who had minor criminal convictions, and as a consequence were put in the immigration system for deportation. Entire families here, entire lives here. And because of their mental health conditions, they were forgotten. In both cases, an immigration judge, and to the immigration judge's credit, said, I'm concerned about the mental health of these men. they need help. The Department of Homeland Security, the prosecutor in charge of the case, in both cases did nothing in response to that concern, and both men ended up detained in immigration detention for more than 4 years. This is just being warehoused in a jail setting without any movement or legal proceeding for years. I represented Mr. Gomez Sanchez before the immigration judge. I know him personally. And when I first learned of his case, his mother came to me and said, "My son got picked up by immigration agents, and I want you to help me find his body. I think he's dead. He's been disappeared into the system. He's struggled with his mental health, and I just need you to help me get closure here." And so on the basis of these men's stories and many others similar situated, this lawsuit came about and won the legal right to counsel on the basis of the argument that I told you. And, this program has been a success. It's operated since 2014. It's assigned defense counsel to over 2,000 people who would not have otherwise had counsel. I don't need to tell you, and we know this from a data standpoint, counsel makes all the difference. If you have a lawyer protecting you, if you have a caseworker connecting you with resources, if you have a mental health expert who's able to form a therapeutic alliance, if you have someone, an investigator who can help arrange a release plan in the community, that makes all the difference. And so we know with a legal team like that, folks are 3 to 5 times more likely to win release on bond, and up to 10 times more likely to win the legal relief that the law entitles them to. And so legal defense makes all the difference. If you want to know more about that and about the NQRP, I've put some links in the slide. I'll just say a couple of more things about the NQRP that I haven't covered that I think are cool. One of the things we've tried to do is take your great work as a field and as a community on person-centeredness, on leaning into empathy, authenticity, mutual respect, and shared decision-making to make that a new model of legal representation and legal defense. The traditional model of legal representation is this arm's length, professionally distanced, agent, client-agent relationship, and for a variety of reasons. But particularly where trust is low, often for good reason, particularly where there's a very serious mental health condition in the mix, we have found that a person-centered model of doing legal defense based on those, what I call recovery values, is more effective. And we are trying to really build that out as we expand the NQRP. And I'll say that the NQRP has also philosophically embraced what I think is kind of the spirit of Olmsted, which is that to really recover, people need to be out of custody, in the community, surrounded by natural supports, with as much autonomy and self-definition over their own lives as possible, just like all people. And so we are really trying to push those concepts in the effort to build out legal representation in the immigration space. And we thank you for pioneering those concepts. And my last slide, Derek, I'm 1 minute behind, but we're still good. I will say there are some challenges on the horizon that you have dealt with in your work as mental health advocates, and that I think and that I invite you to ally with us on. Help us fight these battles, because this is what we're seeing in our space. We are seeing just how dangerous detained settings, immigration detention is for people with mental health conditions. We see just the arbitrary and widespread use of solitary confinement to punish people for having mental health conditions, to disciplinary segregation, so harmful to people, all people, particularly people with mental health conditions. We see the unchecked use of restraints, chemical and physical. We see, immigration jailers ignoring the law when it comes to accommodations requests. We see terrible conditions of detention. There was a 2018 report released by the Inspector General, so a government agency, on conditions in the Adelanto Detention Center in California, where lots of immigrants are held in detention. And one of the major findings of that report was that there were bed nooses made from sheets rampant throughout the facility, and that people were harming themselves with those nooses. And I know how loaded that word is and that image is, but that is what the report found. And that, you know, ICE didn't give a damn about that. So this is real. And just a general lack of accountability for what happens to people, particularly people with mental health conditions in the immigration detention space. I'll say too, and Derek, I really will finish, we see a lack of safeguards or accommodations for people in the immigration court process. We have counsel for some people in those 3 states I mentioned, but there are immigration courts and detention centers in every state. And the NQRP has not reached all those settings. We would like counsel as an accommodation to be available to all people throughout the country who are in immigration detention, people who have mental health conditions. And that's a continuing fight. We see the continued and powerful role of anti-mental health stigma and prejudice against people with mental health conditions. Judges and prosecutors in the immigration space saying, well, if you have a mental health condition, then you're dangerous, and you can't get bond. Just on the regular, that kind of conflation of any mental health condition and dangerousness, and a general sense that, well, people are just simply to blame for their mental health conditions. No sense of the role of social determinants of health in mental health, but just this reductionist and very wrong sense that people are to blame for their mental health and deserve to be treated as blameworthy and as disposable. And also, and I'll say finally, we are acutely aware that when people are deported from the United States and have serious mental health conditions, all over the world, people face hatred, discrimination, violence because of their mental health conditions in places they are deported to. And so we are working to develop mental health status as a ground for asylum and for seeking protection here against the anti-mental health stigma and violence that awaits lots of folks where they may be deported to. Those are some of the challenges. If any of this resonates with you, reach out to me. We can fight these battles together, and I hope we do. At this point, I will hand it over to Derek for a deeper dive into kids in these systems.
Thanks, Gregory. Folks, apologize for the brief pause here. I'm gonna start sharing my screen. I did have some finicky tech issues this morning, so I just wanna check with Emily to make sure things are looking good for y'all. So bear with me 1 second here. Okay. Okay, Emily or Gregory, what are y'all seeing on the screen right now?
We're on the title slide right now.
Great, and you don't see my notes on the side?
Correct.
So it looks like I'm just like brilliant and off book. Fantastic.
Perfect.
Okay, well, thanks, Gregory. I'm gonna take a deeper dive into kids, as he said. I'm sure a lot of you have been hearing about unaccompanied children in the news. So this part of the presentation, I think, is especially timely given the high number of children entering the United States along the southern border. Before I get started, I want to apologize and give an acronym alert. There are 2 acronyms that I'm just going to have to use. I know every group of people, every professional organization is steeped in their own unique acronyms. Immigration lawyers are no different. But the 2 I want you to just keep in mind as we work through today's slides are UC, which is unaccompanied child, and ORR, the Office of Refugee Resettlement. I'll get into what those mean more specifically later on, but just want to have those at the front of your mind in case you're a little unclear what's going on. You see unaccompanied child, ORR, Office of Refugee Resettlement. And I also just want to note that all the information that I'm going to share today comes from publicly available sources, government-run websites, publications, court filings, things like that. Okay. So what is an unaccompanied child? Let's define it. The phrase unaccompanied child is actually a legal designation in nature. So it's, we hear that phrase, kids flying alone, right? Flight attendants talk about them a lot, but also there's a legal definition that comes from two federal laws, the TVPRA, the Trafficking Victims Protection Act, and the Homeland Security Act of 2002. Right. There's also a really important court case to keep in mind, much in the same way that Franco litigation has benefited immigrants with mental health conditions on the adult side. The Flores settlement has really played a really important role in how children are held and detained by immigration in the United States. I want to point out, I'm going to be talking about Flores throughout the slide today, so you should be aware it's an ongoing case, right? It's still open, it's not closed. It's a settlement that has regular conferences between class counsel, right? The Flores class counsel, and also attorneys for the government. All right, so let's break it down. Let's define an unaccompanied immigrant child. It's a child who is under the age of 18, who is present in the United States, physically present, without legal immigration status, and without a parent or legal guardian in the United States who is available to provide care and physical custody, right? So if we're missing any one of those elements, the child's not considered an unaccompanied child for the purposes of immigration. And they lose some of the benefits and privileges that unaccompanied children have. I want to also point out and call back to something that Gregory and I were talking about earlier, which is the nomenclature here, right? Federal law refers to unaccompanied children as unaccompanied alien children, or UACs. But like we said before, Vera, Gregory, and I, my colleagues, a lot of advocates in the space refuse to use that A, and we just refer to them as unaccompanied children, UCs, to make sure we're humanizing this extremely vulnerable, traumatized population. And one positive thing that's come out in the past couple of weeks is that since January, we've seen under the Biden administration some executive agencies as well adopting a similar approach and calling the children unaccompanied children rather than unaccompanied alien children. So we welcome that change. So I want to talk a little bit more about what's the enforcement system for unaccompanied children when they enter the United States. I just want to give a quick and dirty overview so you can understand more what an unaccompanied child goes through once they encounter immigration at the border, all right? So most of the time, unaccompanied children enter the United States by one of two means. They either go to an official port of entry and present themselves to a Border Patrol agent and say, I'm seeking asylum, or I want to enter the United States, whatever it may be, or they either cross the border between two legal ports of entry, right? So normally in the deserts in the southwestern US, across the Rio Grande, those are really the vast majority of children, I have seen children arrive by plane. That's extremely rare for various reasons. Mainly airlines check to make sure children have permission to enter the country they're going to, right? So that makes sense. After they enter the United States, after they're encountered by Customs and Border Patrol, Customs and Border Patrol has 72 hours to determine whether or not that child meets the definition of a UC, right? Does that child meet one of all four of these prongs here? If that child does, then they must immediately transfer that child to the custody of the Office of Refugee Resettlement, right? And if they don't, then ICE takes custody of the child. So it's a really simple flow chart here. I just want to show, if the child's not a UC or the immigrant's not a UC, they go through an experience similar to what Gregory described. And if not, they go to the Office of Refugee Resettlement. And just to be clear, what is the Office of Refugee Resettlement? I'll explain that a little bit more, but just so you know, it's part of the Department of Health and Human Services, which is a cabinet level agency of the government, okay? So how many children are we looking at? Who are the children that are coming? What countries are they coming from? So we have some data here dating back to 2018 through 2019. And we can see a general trend up and a spike in 2014, which was in the news. And then another spike in 2019. And we see that in 2019, there were the highest number of children, unaccompanied children ever entering the United States. That was more than 70,000. We see that the plurality of them are coming from Guatemala, followed by Honduras, El Salvador, Mexico, and then all other countries. This makes sense for a lot of reasons. Those countries are closest. It's easiest for them to get to the United States, right? But for those children in yellow, a lot of them are coming from South Asian countries, okay? A couple other things I want to point out about this graphic here. That data is just for the first 10 months of fiscal year 19. So the total number for the end of fiscal 19 was actually quite higher. I think about 10,000 to 20,000 more children. And I also want to recognize that I didn't include data for fiscal year 2020. The pandemic really changed so many things in terms of numbers of UCs coming to the United States, but also need to highlight one of the Trump administration policies known as Title 42, which allowed the government and immigration authorities to expeditiously expel immigrants as soon as they enter the United States, including children. Right now, there's been an injunction. They can no longer expel children under Title 42, but at least during part of 2020, that played a big part in skewing the numbers. All right, so let's talk a little bit more about the Office of Refugee Resettlement. This is the agency, remember, that takes care of all those 70,000 plus kids that entered the United States in the past few years. The Office of Refugee Resettlement provides new populations with the opportunity to achieve their full potential here in the United States. So as you can tell from this description, this agency wasn't really designed to handle immigrants coming to the United States without status. What this agency was originally designed for was to welcome immigrants, refugees specifically, who had, in advance of arriving in the United States, received permission from the US government to come and resettle here. So really, ORR in the past was tasked with making sure that immigrants, usually families, had housing access, had language classes, had employment access, and were really adjusting to life here in the United States, which is very different from their role now, which still includes that, but is now their biggest program is this unaccompanied children program, and that's their biggest responsibility right now. So there's, as of about 2003, there's been a real shift in what the Office of Refugee Resettlement is. So let's talk a little bit about why these children come to the United States. You know, there are a lot of reasons. It's hard to identify just one, but some of the things we hear most commonly is that they're fleeing violence. They're fleeing gang violence and recruitment, economic insecurity, persecution based on race and religion, sexual violence, domestic abuse. And a lot of them have these sort of pull factors where they're coming to the United States for economic opportunities and a desire to reunite with family members already here. But there are two things I want to point out, right? We can't forget US imperialism and its role here in decimating the economies of many Central American countries in the 80s and 90s. The war on drugs really played a huge role in destabilizing the region and led to the migration patterns that we're seeing today. And also direct intervention in places like Guatemala in the 1980s during the Civil War there. Okay. And also I just want to point out, this slide just has some bullet points, but one thing that's clear is that what children say about the reasons they come to the United States, what they tell that attorney when they meet or a border agent, is not necessarily an accurate reflection of real reasons why they come. The social determinants of their conditions in home country are so varied that some of them don't fully appreciate, understandably, the full scope for the reasons that they have to flee. The example I think of most often is children from ethnic minority groups, particularly in Guatemala and southern Mexico. There are large Mayan ethnic populations in those regions, and there's so much entrenched systematic racism especially in Guatemala, that a lot of the children from those communities who come to the U.S. don't realize that they've been victims of systematic racism, and that's why many of the factors that have forced them to fled have caused them to come to the United States. How do these kids get here, right? It is very rare to encounter an unaccompanied child who's bought a plane ticket from their home country and flown to a city like Tijuana or Mexicali and crossed the border. They travel by foot, car, bus, and train. A lot of them travel alone or with other family members, including other children and extended family. In 2014, the US government estimated that about 75% of UCs traveled with foot guides or coyotes. I have a very mixed opinion on foot guides and coyotes. Many children explain that they could not have come here without them. And many explain that coyotes and other people they encountered on their journey to the United States subjected them to sexual and physical violence, to human trafficking, to kidnapping and extortion. So I think the takeaway here is that the journey to the United States, best case scenario, is an adverse childhood experience. In reality, it's an extremely traumatic event or series of events that sets them up for a continuingly traumatic experience as they enter the US immigration detention system. So what is that detention system? What does it look like? I'm going to take some time now to talk about the experience, what the facilities are like, where the children are held. So the ORR network right now consists of about 200 state licensed facilities and about 22 states. So right, those 200 facilities are tasked with caring and receiving those 70,000 plus kiddos that entered the United States in the past couple of years. I just want to note that these shelters, these state licensed facilities, are separate from the influx and overflow facilities that have recently been reported on by the media. Those temporary influx facilities, they're not state licensed, so there's some different standards of care there and certainly different issues, and we're really concerned about their continued use. We can talk about that at the end of the bit, but I want to go forward and dive deeper into the ORR system that's been set up. So by law, ORR can only keep children in the least restrictive setting that is in the best interest of a child, okay? And those children stay in that least restrictive setting until one of the following things happens. They can be released to family members or other loved ones in the community after a screening by ORR staff, or they obtain legal immigration status in the United States, or they become adults while in ORR custody. Remember, an unaccompanied child can't have legal status in the United States. If they do, they're no longer an unaccompanied child. ORR loses authority to hold that child. Likewise, if they become an adult in ORR custody, they age out and are usually sent to ICE custody, or hopefully, best case scenario, released on their own recognizance to avoid an adult carceral setting like the one that Gregory talked about. So what are these least restrictive settings? There are about 5 categories here. I'm going to break them down for you. The first category is short-term facilities. Then there's something that we call secure facilities, long-term care. And then we have 2 that I'm going to spend more time on: residential treatment centers and out-of-network inpatient facilities. Let's start with short-term care. These are group homes or dorm-like facilities where children stay after arrival. There are healthcare services, allegedly mental health care services as well, and an educational curriculum that I think is about 60 days long. So if a child is there longer for 60 days, that education curriculum repeats, which is a problem not only for their education, but also the length of stay that they're there. The other short-term facility is something called transitional foster care. These are much more child-friendly, and it's something that Vera pushes as much as possible. These are community-based homes, right? So children go and stay with families in the community who have been trained to work with immigrant children who have recently arrived. Right now, the resource is fairly scarce, so they're reserved primarily for tender age children and pregnant and parenting young mothers and their children. These two short-term settings are what the vast majority of children encounter once they're in ORR custody. Okay. We also, I just want to say, transitional foster cares are not only, child-friendly from a mental health perspective, but also much safer from a COVID perspective, right? These are not locked congregate care settings like the short-term shelters are. So we really think as much as possible, ORR should be moving towards that direction. Let's talk about the secure facilities. The staff secure facilities can vary in nature, but they tend to be a lot like the short-term shelters. There's just a higher staff to child ratio. And these facilities are reserved for children who have had some sort of behavioral issue pop up in their records or represent some sort of danger to themselves or to others. Secure facilities are another type of facility here that's locked. And it's a physically secure structure with staff able to control violent behavior. This is the most restrictive option, right? And ORR doesn't have that many of these programs left. There's only about a handful. But when children are sent there, we hear a lot of problems related to the care that staff received, because a lot of these places are part of licensed juvenile detention centers or highly structured therapeutic facilities. Long-term care programs, right? There are two kinds here. One is LTFC, long-term foster care. Similar to the temporary foster care, they're the community-based ones, but the children are there indefinitely. They stay in a home with a family, and they're integrated into the community as much as possible, which is to say, they go to public schools, they take the bus to school, they go and visit doctors off-site. So it's as much as we can approach a child-friendly model for immigrant detention. I think LTFC is the closest we currently have. There's certainly ways to improve every system. But it's much different than the secured settings. The other setting that I'm sure is of interest to the audience today is something called therapeutic foster care. It's like the long-term foster care, but the staff and foster families are trained to meet the medical, developmental, and or psychiatric needs of UCs. So therapeutic foster care is specifically for children with behavioral issues or mental health conditions that require a higher level of care and training. So these last two groups that I want to talk about, residential treatment centers and out-of-network facilities. A residential treatment center is a fairly restrictive setting. And I'm going to quote directly from the ORR manual. It's a subacute, time-limited, interdisciplinary, psychoeducational, and therapeutic 24-hour-a-day structured program. It's only used at the recommendation of a psychiatrist or a psychologist who believes a child poses a danger to self or others and does not require inpatient hospitalization. And we don't have that many of these RTCs, residential treatment centers, in the network, and they're really reserved for children who have more severe mental health disorders. The other type of facility here, of course, in the final category is something called an out-of-network facility. These are hospitals. These are inpatient mental health hospitals sometimes, right? With about 75,000 kiddos coming in. Of course, some of these kids are gonna have medical needs. Some are gonna need an appendectomy. Some are gonna need to go to the hospital for other reasons, right? So it makes sense that ORR sends children to out-of-network facilities when they need care. What we've seen, however, is an increase in use of out-of-network facilities for children with mental health conditions. And children are being sent to inpatient hospitals at an increasing rate over the past couple of years. And there are a couple problems there that I want to highlight for you all today. And this all comes from publicly available court filings in the Flores settlement. I encourage you all to check those out. based on a declaration that one of the attorneys in Flores submitted to the court. What we're seeing is that at some out-of-network facilities, the lengths of stay can be really long. Right? Remember, we're talking about children here. So these children are at a mental health hospital for 6 months at a time. This year, there was a report of one child being there for over a year. There's severe language access issues. There's attorney access issues. Of course, these children aren't getting normal or proper education while they're there. And there's some really significant over-medication concerns. In that declaration filed in Flores, the attorney noted that half the children with whom she met could not even have a conversation with her, and she suspects highly it's because they had been over-medicated. So, of course, these are not child-friendly practices, and I don't think anyone would say that these settings are ideal for children, but that problem is compounded when you remember that the US government is actively trying to deport these children. Each of these children have an active case in immigration court. So while they're going through what can be an extremely traumatizing, difficult detention experience, they also have a legal case to fight. And it's also important to remember, as Gregory highlighted, there is no guaranteed right to counsel for these children, okay? Even if these children are detained for an extended period of time, unless they're in that specific category of long-term foster care, the government does not guarantee them an attorney. If there's an attorney available, Vera does have some funding to pay for them, but it's not guaranteed. So these children are in an extremely precarious position. I want to talk about some more intersections of mental health and OR detention, right? OR has to keep children in the least restrictive setting. Many children in these more restrictive settings that I've been focusing on now are by default stuck in ORR because they don't have a sponsor. The ideal scenario is that a child enters ORR, there's someone in the community with whom they can be reunited, and then they go. And I promise you, ORR is not trying to keep children with behavioral issues or mental health disorders in their custody. They want those children released to families, surely from a child welfare perspective, but it's a liability and it's difficult for them to maintain that child in their system. So the children that we see that are generally in these more secure facilities or in the therapeutic facilities or in the out-of-network facilities, right, they tend to be ones without community sponsors. So they become stuck in this really, really vicious cycle of detention, which leads to decompensation, right? If there's a longer stay in custody, there's an increased likelihood of mental health challenges and behavioral issues. Every time there's a mental health issue that arises or a behavioral issue, there's something called a significant incident report that goes into their ORR file. And once that's in a child ORR file, it is so difficult to get them stepped down to a less restrictive setting or less restrictive program because none of them want that responsibility. So they become stuck, and it's this terrible cycle of shelter, staff secure, out of network for who knows how long, and then they get released and then they go back through that system all over again. It's detention fatigue, it's trauma, it's re-traumatizing the children at every step along the way. And one other thing to really keep in mind is many of the secure facilities were not designed to work with immigrant children. They are or were part of states' juvenile justice systems. So what this means is that the infrastructure, the staff, the training, it's not meant to be least restrictive, but rather to address the needs of children with juvenile justice adjudications, right? They're meant to deal with children who have committed things that would be considered crimes had they been adults. So when you're dealing with staff that's quick to criminalize or be punitive in nature, it leads to the recriminalization of children and further detention. All these things wind up in their record, and that record gets shared with ICE, who is actively trying to deport these children. So in some ways, these secure facilities are the default permanent solution, but it's far, far, far from something that should be a solution for children. I want to turn now and talk a little bit before I wrap out about what are the standards of care here, and highlight some things that I hope maybe this audience can help Vera on during its advocacy. There's a loose set of guidelines that ORR has set forth in its policy guide. It seems, at first blush, like a really, really comprehensive guide, but it's far from detailed. And I think one important example is that ORR requires every program to provide mental health for children. It doesn't say what type, provide mental health care for children. It doesn't say what level of care. It doesn't say how often that care has to occur. It doesn't, it doesn't mention if it's simply interventive or if it's something that's more ongoing, right? So and furthermore, in the context of mental health care, it's usually mentioned in the context of sexual abuse in ORR custody. So it's clear that mental health care and therapies, as far as the ORR policy guide is concerned, is really aimed at, excuse my language, covering its own ass, right? When something goes wrong while these children are in custody. But wait, there's a little twist here, and something that can be great and something that can be not so great. Flores, the judges in the Flores case intentionally required that all these 200 facilities be licensed by states, right? So what this means, at least in theory, is that these programs have to be licensed by states and therefore meet the requirements and standards of care that any other facility in that state would also be beholden to. So state laws serve as ideally as an additional safeguard for unaccompanied children in ORR custody. But that's a problem. Why is it a problem? We have 22 states with shelters, as I said, with 22 different licensing requirements and protocols, and 22 vastly different approaches to immigrants and the rights of immigrants while in custody. I'll give you two quick examples here. In California, there's something called the Foster Care Bill of Rights, or Foster Child's Bill of Rights, my apologies. And the ombudsperson for California foster care has taken it upon itself to say that this Bill of Rights also applies to children in ORR custody in California. So that's a real benefit, right? To be in a state, or at least in an office like the California ombudsperson, who believes that immigrant children are in no different from their domestic counterparts in California, right? So there is some oversight in a place like California. Let's contrast that to a place like New York, which has also held itself as being extremely immigrant friendly and a leader in the immigrants' right movement. The problem in New York is there is no real clear transparent oversight. There seems to be some licensing and oversight agencies, but there's no clear mechanism. There's no releasing of reports. So what you can see, even in a state like New York, which is more progressive in terms of treatment of immigrants, it's a problem as well. And I'm going to call out states like Texas and Arizona, which have high numbers, which have high ORR bed capacity, but whose legislatures and governments haven't taken a similar approach. And so there's really a lack of oversight in places like that. And so that's something that Vera is actively working on, trying to increase oversight. I know I'm coming up on time here, but I just want to make a plug. If any of you, specifically you who practice or work in New York, would like to chat with me and my colleagues about state licensing and oversight, that would be great. It'd be really informative for us as we move forward in a push for more oversight there. So finally, I just want to wrap up with one more issue about the intersection of mental health, asylum, and UCs, right? My training is as a lawyer. I don't have a social work background or mental health backgrounds. So this is just immediately where my head goes. And I want to point out that the intersection of mental health and asylum can be really important for the benefit of an immigrant. And let me explain how. So what is asylum? I'm sure you've all heard of it, but it's a legal benefit. It's indefinite permission to stay in the United States because of fear to return to country of origin based on persecution because of one of 5 protected grounds. Now, this is the quickest, dirtiest overview of asylum. Please forgive me, those of you who know more about it. But I just want to point out, what are those 5 protected grounds, right? There's race, nationality, political opinion, and membership in a political social group. Let's do a review real quick. Race is obvious, right? If you are a racial minority in a country that systematically harms or persecutes members of that race, example in the news lately, the Rohingya minority in Burma, Myanmar, right? That would be an example of race-based asylum, and there are a lot of refugees who have come from that part of the world and qualified for asylum here in the United States based on their race. Political opinion, obviously, as well. About 1.5 years, 2 years ago, due to political unrest in Venezuela, there were a lot of people who qualified for asylum in the United States based on their opposition to the government in Venezuela. Religion as well. Let's take someone of a Jewish minority in a country like Iran, right? That would be a basis for it could be the basis for asylum here in the United States. This last one, membership in a particular social group, is, I don't want to call it a catch-all, but it's certainly the most amorphous, and it's the one that us lawyers spend the most time on because it gives us the most to work with. Quick example, the easiest example is people who identify as LGBTQIA+. We all understand the gay community, the LGBTQ community, and that's a clear social group under US asylum law. Less clear, but also certainly grounds for asylum law, are women who were subjected to FGM, female genital mutilation. US asylum law, case law, has established that yes, that can give rise to membership in a particular social group. That can also give rise to the granting of asylum. In the same way that members of a particular family, if you're part of a family that a government has something against, you might qualify for asylum specifically based on that. And then there's certain health conditions, right? People who are HIV positive or who have AIDS have won asylum based on that membership in that group because of the way that people with that condition are treated in their home country. And then finally, just to bring it full circle for you all, people with certain mental health disorders have also won asylum claims by virtue of having those diseases, and by virtue of the way that their government and communities and healthcare providers, or lack thereof, treat and persecute people with certain mental health disorders. So I just want to wrap this up and say, because mental health can be the basis for asylum, from the lawyer's perspective, anytime one of our clients is having a mental health condition, it is so imperative that we can have access to their doctors, to their medical records, because we can use that to build their case, which almost all the time is in that child's best interest. So when these children are being sent to out-of-network facilities where there's really, a lack of communication, and in some ways, for the lawyers, many times it's sort of a black site, that can really kill and hamper a child's case when it otherwise could be quite successful. So I'm going to end there. Apologies, Emily, I'm a little bit over, but we'll turn it over now to questions and some questions for the group.
Could we just go through this one last slide?
Sure.
Just thank you, Derek, and Emily, I'll be very quick. But we wanted to end just with a call for solidarity on some of these points, that things that we think that we could do together. We would love for the mental health advocacy community to join our call for legal representation for all immigrants, and particularly legal representation for people impacted by mental health conditions, representation that is person-centered and zealous, that fights every case hard, with no notion, rejecting the notion that people with mental health conditions are somehow less deserving of legal representation, which we reject that notion. We hope you can join us in that call. We are acutely aware of and mindful of the continuing harm of immigration detention for all people held in immigration detention, but particularly for people with serious mental health conditions, and the resurgence of some harms that this community has successfully fought against, including this just unaccountable and pernicious, harmful use of segregation and prolonged warehousing of people because of their mental health conditions. We want to help us, we would love your solidarity in helping winning access to care for all people, regardless of immigration status. People need mental health care. And one key for us to get people out of immigration detention and back into the community is being able to connect them to systems of care and support. And if legal status is an obstacle there, then that literally is keeping people locked up. So we believe in access to care for all people, regardless of immigration status, and would ask that you join us in that call. And then finally, you know, we know that you do, but it's good to say again, how systems impact one group of people with mental health conditions, so they impact all groups of people with mental health conditions. So please join us in regarding immigrants with mental health conditions as your community too, and to seeing the interdependence and links among the communities that we stand alongside of and advocate for. Thanks.
Wonderful. Thank you both so much for sharing so much great information. We've got about 15 minutes left for Q&A, and we've got a bunch to start with, so we'll jump right in. When children come with an adult other than their parents, who decides if that person can be a legal guardian for that child in the U.S.?
Yeah, so well, if they come with someone who's not a legal guardian prior to entering the U.S., they're not a legal guardian, right? They would have to go through the domestic courts here in the United States to become a legal guardian. So the answer is, if it's not your parent or legal guardian, as far as Border Patrol, immigration, ORR cares, that child has no legal guardian. It's only then after months later that a child could then be placed under the care and custody legally of that person.
Do unaccompanied children have to attend immigration court hearings without legal representation ever, or even a caregiver or advocate that can speak on their behalf?
Yes, 100% all the time. And that is one of the biggest fights that we're having right now. That's one of the highest things on Vera's agenda. The same legal team that brought the Franco case actually brought a similar case for children, using similar legal arguments, and unfortunately that case lost. So as you can imagine, a child, specifically an unaccompanied one, has to go to court without anyone but the judge and an attorney who's fighting to deport them. It's just one of the most heartbreaking things you could ever see.
So aside from providing services after the trauma, what can be done to make the journey and process less traumatic in the first place, especially for those unaccompanied children?
Gregory, do you want to jump in here? I mean, there's so many things here, right? I'm assuming by journey you mean through Central America and Mexico. That's a much larger geopolitical question that we could spend months and years talking about policies and international relations solutions. I'm not gonna try to answer that part, but if we're talking about the journey through the ORR detention system, I think it's minimizing lengths of stay as much as possible. I think it's not making potential sponsors jump through such an exhaustive obstacle course to prove their suitability to welcome a child into their home after being detained. And we've already seen some of that already in the past few months, so that's a positive sign. And I think it's a move away from congregate care settings and a push to the foster care model as much as possible, and getting more experts, more social workers into the ORR system who can help do those screenings in a more effective expert way than they're currently being done.
Great. What is the current status on unaccompanied children being put in detention centers at the border?
Yeah, so I'm assuming this is a question, I'm going to assume that this is a question about these sort of tent cities, convention centers that we're hearing pop up in some southern parts of the US. The status is, unfortunately, these are being considered influx overflow facilities, so they're not given the full ORR treatment, which means me as someone who works for Vera, who's a subcontractor of ORR, has no access to those facilities and has no responsibility to go and give the services that we normally give, the legal screenings, the legal consults, the know your rights presentations. My understanding is another organization has been contracted to do that at some of the facilities. And my other understanding is that the goal right now is that those facilities will process and release kids to the community as expeditiously as possible, keeping in mind COVID quarantine requirements and the potential for child endangerment to certain sponsors.
And what is already in place to give those mental health services to children who have been separated from their parents during the immigration process?
Yeah, so specifically, there is a court case that has found that the government must provide mental health services to families that were separated and then reunited. So it's sort of a sorry, we tore apart your family, but we'll give you some money to see a therapist now. Certainly better than nothing, but still atrocious. More specifically, what's happening now to children that go through the system, whether or not they've been separated from a family member, varies so greatly, not only by state, but by program and ORR facility in each state. There's some programs that have twice weekly group therapy. There are other programs that have one-on-one talk therapy for children. And then there's some programs that meet the absolute bare minimum, whatever is required by their locality. It is such a mix. All I can say is that I was lucky enough to do my work in California, which the programs in Southern California that I've worked with have done a really as good a job as can be expected in that setting. I'm not going to say that the setting is perfect because it's a congregate care setting for children in detention, and I always will fight against that. But there are real continuous efforts to provide mental health services at some of those facilities. And what I found is that that is absolutely not the case in the rest of the country.
Switching gears a bit to a much more general question, can you speak to the importance of language within all of these systems? So for instance, using unaccompanied child versus unaccompanied alien child, other things like that.
Gregory, you want to talk about that one?
Sure.
Yeah.
I mean, you've spoken to it so well, Derek. I would just say that in the same way the mental health community, I think, very rightly pioneered person-first language to keep how we talk about people focused on people as people and to honor the innate dignity of the person. So we so we use the same person-centered principles here. The way we talk, just as you have shown us in your work, is focused on seeing the people that are impacted by these systems always and first as people, not as disposable, not as the system would have them see us, not as the law enforcement folks would have them see us, and no disrespect to those folks, not as how the predominant narrative would have us see them, but as people who deserve to have dominion and say in their own lives. And so that is the importance in how we use language. And I think, again, it has to be said, that is directly following your example of pioneering people first language in the mental health advocacy space.
Great. And we've got 5 minutes left and one last big question. Do you have any article or book recommendations on the effects of these experiences on mental health and well-being?
Well, Derek, I'll say a couple, then turn it to you. If you want to understand the connection between the immigration, mental health, and criminal systems, I can lift up the Lena Das article, Inclusive Immigrant Justice, that I mentioned earlier in the slides. It paints the connections between those systems, and it does so in a framework of understanding how white supremacy and racial discrimination really has animated the most harmful effects of those systems. So I can commend that article to you. I think I can also say, though, that one of the ways that you can help us is we simply need more research and writing about these systems, because one of the most dangerous things when it comes to how these systems impact people with mental health conditions is their opacity and their lack of accountability. So in order to hold systems accountable for the harms that they visit on people with mental health conditions and all people, we need to know what they're doing, and we need to confront them with facts, and we need to build political pressure with people's stories, of course with their consent and with people driving those stories. But we need more research and more sunlight on these systems. And so use your research capabilities. Use your access authorities. Some of you can get in places where people with mental health conditions are held that nobody else can get in. Look for immigrants in those systems and ally with them, and in a person-centered way and with their consent, tell their stories. So, sunshine is a major answer to where's the research. We need more, and we need more sunshine, and we need your help with that.
I'll make a slightly different reading recommendation here. I'm going to put it into the chat right now. It's the latest court filing in the Flores case, and maybe okay, the lawyers in here can go ahead and dig into the pleadings at the beginning, but the rest of you and all of you should really check out the declarations that follow. They're really informative, and this is some of the best sort of primary information we have. There's some declarations, anonymized, redacted from children in those facilities as well. So I think it'd be a fascinating read for a lot of you.
Fantastic. Great. Thank you for that. We've got 2 minutes left. Any last words from either of you?
Just thank you for letting us be in the space and to share our perspective, and for your engagement and time.
Yeah, likewise. Thanks everyone for caring. It's always nice to hear, and I think Sunshine talking about these issues is really important to keep it, in the discourse, because these problems aren't going anywhere, and they're only getting worse. So we need to focus on them.
Absolutely. And right on time, 3:45, we will wrap there. Thank you both so much for such a fantastic presentation today. And thank you to everyone who joined us. I'll be in touch in the next few days to get everyone that link to the recording and the link to request your certificate of attendance. Thank you all, and enjoy the rest of your day.
Thanks so much, everyone.